Hi, this is Brian Wickland with Garfinkel Schwartz. I'm coming to you from our Maitland, Florida office today. We also have an office in Cocoa Beach, Florida, which is near the port on the east coast of Florida. I'm talking to you today about attorney's fees. We call them no-risk attorney's fees. These attorney's fees are under a federal law that's called the Longshore Act, and by a subset of it is the Defense-Based Act. That's the type of law we practice. In this area of law, the attorney's fees are very advantageous for clients because the attorney's fees are negotiated and paid completely separately from whatever benefits you're entitled to under the acts. We call it no risk because the way our firm works is that I screen the clients, and when we determine that we're going to help and that you're going to sign up with our firm, that's me making a risk determination that you are entitled to benefits, whether that be medical benefits or money benefits. It doesn't matter. I take the risk with you. We take the risk with you here at Garfinkel Schwartz. We advance all the costs in the matter. We don't ask for a dime from you ever. And we're taking the risk that we're going to get benefits for you sooner or later. The way that we get paid is simply my hourly rate wherever I am in the country, with the prevailing hourly rate wherever I am, times the number of hours that it took me to get whatever benefit you got after you had to hire an attorney. That money is paid completely separately from your money, no percentage, nothing. It's negotiated separately with the insurance company or directly with the employer, whoever's on the hook for the benefit that they had to pay you, that they denied you previously. Separate checks come. You get a check in the mail directly to your home, usually by FedEx, so they can track it. We get a check completely separately to our law firm for our hourly rate times the number of hours we spent. All of our fees have to be approved by the Department of Labor. There's a form, a retainer form, that I cannot change, and that's a form drafted by the Department of Labor. The only time that you would ever pay any money in any circumstance for legal fees in this area of law, at least the way that our firm does it, is if you fired the firm and then later you got benefits conferred upon yourself. We would be able to file a lien on the proceeds to get the hours and time that we used to your benefit. That happens unbelievably rarely, obviously, but that is our right. We would be able to take money out of a settlement if that occurred. Like I said, that happens very rarely. In terms of percentages, everyone always mixes this stuff up with state workers' compensation type things. There's no percentage. We're not allowed to charge a percentage. If a lawyer charges you a percentage in this type of law, you know that they're doing something wrong and they don't know what they're doing, because the law is the hourly rate approved by the Department of Labor times the number of hours that I expended on the claim plus the costs that we advanced on your behalf. Those costs may include medical evaluations that we advance on your behalf. Not treatment, not allowed to pay for treatment. We pay for medical evaluations to see exactly what's wrong with you, to usually combat the insurance company saying there is nothing wrong. It's advanced costs for deposition transcripts, mediation services if any arise, medical records that we have to gather on your behalf. Those are all costs that are advanced that will be recouped if we get a benefit for you. If we lose for some reason and we don't get a benefit for you, then I took a bad risk, and we take the hit for that. So if we lose, we don't ask you for any money. If we win, we get money completely separately from the insurance company or the carrier. I hope that clarifies the attorney fee situation. So the reason the law is out there is for your benefit, to get counsel to go against these giant insurance companies that have counsel, army of lawyers on their side. And if you would have to pay, if you're not being paid benefits that you're due and you don't have any money, how would you be able to hire a lawyer and pay them an hourly rate, or take a big chunk, a percentage of your surgery money or medical treatment money or indemnity money that in other areas of law like personal injury, lawyers take a percentage, and that helps the client because they wouldn't be able to pay an hourly rate. So that's why contingency fees exist. In this area of law, like I said, it's contingent on getting a benefit, but it's not a contingency with a percentage. So thank you very much. I hope this helps. Please call us anytime. Always free. No free consultation. It's a free everything from here on in until you get the benefits you deserve. So like I said, we call it no risk, and it really truly is no risk to you unless you fire us and then get benefits from someone else or for yourself. That wouldn't be fair. So like I said, that happens rarely. And the Department of Labor, they do actually pour through my bills and go through and cut out things that they don't think are relevant, and they come to a resolution as to what my approved fee would be. Again, I said separate checks, completely separate from any issues that you're involved in. Again, thanks for listening. I hope I was some help. And this is Brian signing off at Garfinkel Schwartz in Maitland, Florida. Thank you.